I'm Larry Maxwell in Dallas, Texas, and I appreciate the opportunity to visit with you about the civil collaborative process. You might be interested in how I came to this point today. My background is as a trial lawyer in Dallas, in the state of Texas, and elsewhere for over 40 years. It was a very valuable and rewarding experience, and I wouldn't trade my litigation days for anything. But several years ago, in about 2000, a colleague of mine, Sherry Abney, came to me and said, let's go find out about this collaborative law process. And that was of interest to me because it's a settlement process outside of the courthouse. And in my days in litigation, I was somewhat in my law firm known as the settlement lawyer. And that is, I would try my best to get a case settled before we got to the courthouse. And most of them did. The vast majority of them, as you know, today like 98% of the cases, suits that are filed are settled before they get to trial. So we went to this training by an individual here in Dallas. I think it was in 2000. It was in family law. It was family law. And of course, as you know, this process has its roots in family law. Much the same as mediation. When mediation was starting in the late 80s and early 90s, started in family law. And as you know, mediation has done quite well over the last 20 years. It's now nationwide and worldwide. The process is accepted. So we took this family law training in the collaborative process in family law, and I just found it fascinating. So I started digging into it. About that time, I was about through with the litigation process. I had been involved in some major litigation in East Texas that lasted for 12 years, if you can believe that. And it finally got resolved. At one time, there was, 3,000 plaintiffs and over 400 defendants. And at the end of the day, I had responsibility for getting it all wound up, getting the settlement documents. And I looked around and said, maybe I've had enough of this in my life. So I went into this full bore. As a trial lawyer and a trial lawyer doing your job, you're almost in a schizophrenic condition because you from the time a petition is filed or an answer is filed, you need to be thinking about, if this thing goes to a jury, this is what I need to do before we get there, okay? And at the same time, you want to do your best to assist the client and try to get the thing settled and not have to go to trial, to avoid the trouble and expense and aggravation and emotional upset of that. So that was appealing to me. I've written articles and papers about it, and I call it the first option. And the courthouse is there, and it's going to be there. And in this process, not everybody is a candidate for the collaborative process. Not every lawyer, not every party, not every dispute. But the vast majority of the things that arise in the area of civil law, this process will work if the stars are aligned right. So, and for me to make the transition, and my colleague Sherry will certainly confirm that it requires a paradigm shift, a change of mindset. And for me, that was not real easy with that kind of background. And I think I'm completely broken there. Some of my colleagues call me a reformed trial lawyer, and maybe it's still reforming. I don't know. But in this process, it's just so different from what goes on. I mean, the simplest way to describe it is interest-based negotiating versus positional or rights-based bargaining. And you're familiar with the steps in the process. Once you get that mindset and you start operating that way, then it's face-to-face meeting, and the first step, the simple 5 steps, is you determine the interest and the goals and the concerns of everybody in the room. And then the next step is you gather relevant information. What's relevant? Well, if you need it, if I'm going to walk in your moccasins and I need it, then it's relevant, and you put it on the table. And the next step is you develop options for getting the dispute resolved. All the options. Put all the options on the table. Don't get into evaluating options until you get everything. And the next step is you evaluate options. You look, this will work, this might work, this won't work, throw it out. and then you arrive at a settlement. And we've just seen this work beautifully. I mean, we've had in the probate world, which is in will contests and in contested guardianship, where you want to maintain the relationships. You can't do that in the courthouse. I mean, the family's going to be torn apart. It just won't work. And in the business and commercial world, the same thing. You can maintain relations. These are the type of things that attracted me to this, because those kind of things can't happen in the courthouse. And as you know, in Texas, in the family law code, there is a provision for collaborative law. It was put in the Texas statutes in 2001. We really got involved in the summer of 2004. A group of like-minded lawyers in Dallas set up a Texas nonprofit corporation, 501c3 exempt, called the Texas Collaborative Law Council. Now, a group in Boston of our colleagues had set up the Massachusetts Collaborative Law Council, I think around '02 or something in that neighborhood. So we were in touch with David Hoffman and Michael Zatunian and Doug Reynolds and other like-minded lawyers in the Boston area. So we set up this corporation and established the mission, very simple, to educate the public as to the benefits of the process, to train lawyers and other professionals in the process, and to, of course, preserve the integrity of the process. And I think to this point, Sherry Abney is our lead person in developing training, and we've trained over 250 or 300 lawyers and other professionals at this point, as a group in Boston has too. And the growth has just been phenomenal. I mean, quite hard to believe. These early people in Dallas had a vision and had aspirations. And just to give you an example of, in the last few years, how this thing has taken off, the American Bar Association, the section of dispute resolution in '07, early in '07, the established a collaborative law committee. Really very helpful, David Hoffman in Boston, who's one of our colleagues in Boston. And that committee continues to grow. It has regular meetings, of course has a listserv on the ABA website, so there's communication among lawyers. Now, further with the ABA Committee on Ethics and Professional Responsibility came out with a formal opinion. It was in '07, I believe, also, which squarely supported the collaborative process, lawyers engaging in the process, provided that the client is well informed and knows the process and the alternatives that are available, such as mediation or arbitration or litigation. Following on to that opinion was really came about because before that there had been 6 or 7 states that had issued ethical opinions on the process and lawyers' involvement. And one state, Colorado, issued what I would call the maverick opinion, which said lawyers couldn't do this, couldn't sign a participation agreement. So I think that really brought about the ABA opinion. The Collaborative Law Committee of the ABA, we put together a subcommittee and drafted a white paper, and took all of the opinions, state opinions to date, and the ABA opinion, and the Colorado opinion, thoroughly analyzed them, and that white paper is available now. It's on the ABA website for the Collaborative Law Committee, as is the ABA opinion.